proud, and it's recording now.
Fantastic.
Fantastic.
Well, hello everyone, and welcome to the latest of Practico's Costs Chat Between Friends. It's just over a year now since we had a cost chat actually in person with the bacon sandwich and all that in the Devonshire Club near Andy's work. And I know the date precisely because that's the last time I was in the UK. For those of you who don't know, I live in Italy and haven't been able to travel to the UK for that time. So all the cost chats we've had in the meantime, of which this is probably the 6th or 7th, have been virtual ones. And they've gone, I think, quite well, given the technical problems that would otherwise be there. But in order to celebrate the little over a year anniversary since the beginning of lockdown, at least here and to some extent also in the UK, we're going to conclude with a little discussion, a chat about how it's been for all of you during lockdown, trying to work remotely. But in the meantime, we've got some, sorry, I haven't introduced the participants, who the friends are. The friends are Andrew Post QC, leading cost counsel, and Andrew Ellis, who's the managing director of Practico, and I'm Jeremy Morgan, retired cost counsel and consultant to Practico. I have to say, Andrew and I really are friends. I think I probably set him on the road towards becoming an expert in costs when we were in Chambers together a very long time ago.
All true. It really is Jeremy's fault. Yes, absolutely. Jeremy is the person who came into my room and said, I've got this thing. What's a judge going to say? And I sort of say, I've no idea. But he kept on coming in and asking these questions. And after a bit, I started to get a feel for this esoteric world.
And there you are. And look where he is now. The Court of Appeal has been very kind to us and given us a decision last Friday, which we will talk a little bit about, which is about whether litigation funding agreements are DBAs. Before that, probably we're going to start with the more important issue of DBAs and whether you can have hybrid ones and what happens if you have a provision in the agreement whereby the solicitor gets paid if the client terminates the agreement. And after that, we'll have a quick trot over a couple of other things. The first, which is opt-in funding in group litigation and how that's going to pan out in the light of the recent Supreme Court decision, and the possibility of partial relief from sanctions, whether that is something that's going to take off. And then finally, we'll have a chat about how things have been during this period of lockdown. So if I may, I'd like to ask Andrew to kick off with the recent case of Lex Law.
Thank you very much, Jeremy. Right, well, Lex Law is the cost excitement of 2021 so far. And it is, it grapples for the first time, the Court of Appeal for the first time, with this difficult question, or this what we all thought was probably rather a difficult question, as to what the effect is where a DBA is worded in such a way that, as well as there being a share of the spoils, there is also a provision whereby the solicitor will be entitled to get their costs on an hourly rate basis if the client terminates the agreement before success is achieved. The underlying difficulty with DBAs is, of course, the same as the underlying difficulty with the enforceability of CFAs that led to the cost wars. And that is the basic model of the approach that Treasury Council took, that Parliamentary Council took when drafting the law, the Act and the regulations in the first place. And the approach that was taken was to say that DBAs are unlawful unless they comply with the Act and with the regulations. And that, of course, as I say, is the same model that was the CFA model. And the way it was put in the Lex Law case is what that means is that lawful DBAs are islands of lawfulness in a sea of illegality, which is nice, colourful way of putting it. But what that has meant is that the process of actually ensuring that a DBA is in fact enforceable is quite a difficult one. And the fundamental difficulty is Regulation 4 of the 2003 DBA regulations, which provides that in respect... did I not say 2013?
You said 2003, so 2013.
I'm so sorry, I'm entirely behind the times. I obviously mean the 2013 regs, but there were no 2003 regs. I apologise. Thank you, Jerry. And it's Reg 4, Subreg 1, in respect of any claim or proceedings other than an employment matter, a damages-based agreement must not require an amount to be paid by the client other than the payment. And the payment is defined elsewhere as the share of the spoils. The DBA in the Lex Law, or Lex Law's DBA, provided that as well as the share of the spoils, if the DBA is terminated, entitled to their costs. And on the face of it, therefore, the DBA, in breach of Regulation 4, provides for a payment other than the share of the spoils. Court of Appeal, it was pretty clear from the judgments, didn't want DBAs to fall. There was clearly a policy interest in DBAs being found to be lawful. That's apparent from all three of the judgments. It's a court of three, Lord Justice Lewison, Lord Justice Newey, and Lord Justice Coulson. First judgment is given by Lewison, and his solution to this problem is to say, well, what is the DBA? The DBA is the sharing of the spoils agreement. It is the agreement as to what the share is of the recoveries. It goes to the solicitor, and what's the share that goes to the that goes to the client. Any other provisions may be part of the retainer. They may even be in the same document, but they're not strictly part of the DBA. And therefore, Regulation 4 doesn't bite on a payment in circumstances where the solicitor ends the retainer, where the client ends the retainer and is therefore liable to pay the solicitor. And that, therefore, gets around this difficulty of the apparent breach of Regulation 4. The problem with that is that if the regulated bit of the agreement is just the share of the spoils, then anything else agreed between solicitor and client is not regulated, or at least is not regulated by the DBA regs. And the effect of that is that not only can the solicitor charge the client if the client terminates the agreement, but also the solicitor, there's nothing on the face of the regulations to stop the solicitor charging the client full hourly rates, as well as a share of the spoils. Second judge, Lord Justice Newey, raised that and says this does not seem to me to be satisfactory. It does not seem to me that the point of the regulations is to allow the solicitor to recover his hourly rate and a share of the spoils. Therefore, his approach is a different one. He says that as a matter of construction, although the DBA does encompass the whole agreement, payments on termination are, as a matter of construction, outside the scope of Section 4 of Regulation 4, and therefore no breach. The third judge is Lord Justice Coulson, who we know is particularly interested in cost matters. And what he does is he broadly agrees with both of his brethren. So he agrees with, unhelpfully, it's often the case with a three-judge court. He agrees with both. So therefore, there is a majority for the proposition that the only regulated bit of a DBA is the bit that shares out the spoils. That the DBA regulations do not apply to other provisions, and that's one of the interesting things we're going to have to think about. And I'd be interested to hear what you both think about whether, by effectively a side wind, the decision in Lex Law has meant that all forms of hybrid DBAs are now lawful. Because if it is only the bit of the share of the spoils, then the only restriction is what share of the spoils you can have. And on the face of it, you can indeed say, I would like full hourly rates, and I would also like I would also like a share of the spoils as effectively a success fee. Now that's obviously a slightly disconcerting prospect, and I shall be interested to see what you will think about it. Why did this happen? Answer: because all three judges absolutely clearly read the regulation purposefully. It is absolutely clear from all three judgments that they take the view that the intention of Parliament was to render DBAs lawful, and that they were determined, therefore, to make them enforceable. And they didn't see why something as anodyne as letting the solicitor be paid in the event that the client terminates, quite reasonably, didn't see why that should prevent DBAs being enforceable. The problem is that because of the underlying approach of saying everything's unlawful unless it precisely accords with the regulations and the Act, that's quite a difficult thing to do. To my mind, there's been quite a heavily purposive reading of the regulations in order to achieve that.
But it's very difficult, isn't it, Andrew, when you have two judges, one says one thing, the second one is really quite rude about the first one's judgment, to the point where the first one adds an addendum to his to say, well, I'd just like to respond to Lord Justice Newey on this. This is my answer to his objections. And the third judge says, well, I agree with both of them. So you've got two judges who, patently don't agree, and the third one says, well, I agree with you both. Where does that leave us? I think you're probably right. Technically, it does leave a majority in favor of the Lewison solution, which would enable you to do what you've just suggested, which is to say, all right, I'll have all my costs and my expenses, and I'll have a piece of the action on top. But I don't see that an equally purposive approach somewhere down the line wouldn't stop that. Quite how it's achieved, I don't know.
Well, I agree. Well, I actually ought to turn to Andy, but basically, I agree with that, Jerry. Andy, what do you think?
Well, I agree with both of you. It's obviously a very, very fashionable way to present it. I'm troubled by it. Because it's not our job to say whether we think it's a good decision or not. Because once the Court of Appeal have made a decision, that should be it. But it makes me wonder whether it's not really going to be clear in people's minds and be taken clearly into practice, risk-free, until the regulations get tightened up in one way or another. So it seems to me that there's a lot left out there because of exactly what you say. There's one thing to say, let's take a purposive interpretation of this because we know that Parliament wanted to bring these in and that they were supposed to work and they shouldn't be tripped up on technicalities like that may have not been foreseen at the time, like termination agreements. That's a very benign end of it to something which is riding a coach and horses through every sort of principle of cost that we've been brought up with in many respects, which is to say that if you're going to have one of these statutory forms of retainer that enable you to do something that you wouldn't otherwise want to do, it's got to be within pretty tight tramlines and not something that you can just bolt on to another form of retainer. And so therefore, I'm turning round to, you know, the way that here am I, who am I, but I'm criticising that decision in terms of the way it's delivered. And I wouldn't imagine that, I think greater brains than I would find a way to nevertheless argue that to proceed on a cake and eat it basis, for example, if somebody tried to do that, that wouldn't have been overreaching in some shape or form.
I think one thing we can say, but just in case people are worried about the uncertainty this decision creates, is that where you have, if I can call it a conventional DBA, which does have a termination provision. I mean, you've got here 3 Court of Appeal judges all saying that's fine.
Absolutely.
So I don't think people need worry about entering into an agreement like that. But it's if they try and push the envelope in the way that Lord Justice Lewison perhaps has suggested, then they might get into difficulty if they go too far.
Mm.
Yeah, I agree with all of that. I mean, I think it is I think the courts will find a way to stop the cake and eat it situation being lawful. But I think there is a scope for there being quite a lot of litigation about that. I think that the intention, that the difficulty that the 3 judges are trying to address of the quite straightforward payment in the event of termination, I think that we're now clear on, and that is now enforceable, and that's a good thing, because you know it's absurd to have a scheme whereby DBAs are in theory lawful but in practice unusable. I mean, that was hopeless. The slight bad news is that I think the view of the government will now be, the view of the MOJ will now be, the problems are solved. We do not need reform of the DBA regulations because it's all been resolved.
And the big issue which has led people to seek reform of the DBA regulations was probably rather less this point, although to some extent it was there, but also the point of whether you can have a hybrid, what's called a concurrent hybrid DBA in this decision, which is one where if you win, you get your share of the proceeds. But if you lose, the client still pays you something, but a lot less, a reduced
absolutely,
in order to spread the risk a bit more and to make the arrangement more attractive to solicitors. And that one seems to be still up in the air. Would that be right, Andrew?
That's my view. I think it's thoroughly up in the air, and I think I'm far from clear whether that form. I think a consecutive hybrid is fine, but I think a concurrent hybrid may well not be fine on the basis, reading as a whole those 3 judgments, reading the judgment of Newey, who doesn't like hybrids. That's pretty clear. Certainly doesn't like concurrent hybrids. And therefore, I have some doubt about that.
So
now, what about people? Sorry,
I just ask, how would consecutive agreements work in practice? What would be an example of one, a sort of scenario that would be consecutive?
Oh, you can have certain stages covered by one form of funding, and then the next stage covered by a DBA. Exactly. Which I can see it's going to be attractive actually to quite a lot of SMEs, for example, who don't really, who let's see if we can get an early settlement. If we can get an early settlement, we can pay you for it without losing a share of the pot.
Yes.
So I think consecutive DBAs are a realistic prospect.
Yeah. Well, the other way might be conventional. I mean, for the same sort of client, a conventional retainer to investigate the claim and advise on the merits, and possibly get it off the ground. But then as soon as things start getting a bit heavier in terms of costs, you switch over to a DBA.
Yeah. No, that makes
What
sense.
about, as a practical question, somebody who's very, very conservative, a solicitor who's very conservative, has got a very carefully drawn up DBA, which doesn't entitle the firm to be paid in the event of the client terminating the agreement because they were worried about this particular point. Would they be able to amend their agreement now to put in a clause like this?
I mean, generally speaking, anyone, provided the parties agree, can amend a contract to do more or less anything, can't they? But it's this whole difficulty of informed consent.
Yeah. Well, informed and consideration, I suppose, there, because the client
and consideration too.
You're stuck with that one, mate. Sorry.
Exactly. Yeah. Yeah. So what's changed?
Yeah.
I think that, you know, how do I get a benefit out of that? The client says.
Well, right.
You'd have to change the consideration.
Yes.
You'd have to change consideration. They'd have to be something in it for the client.
Yeah.
Yes. Maybe slightly take the edge off the percentage of
yeah
damages that you're going to receive as a result, something like that.
But then, as you say, you've still got to deal with informed consent.
Yeah.
And you've still got to deal with informed consent.
Yeah. I mean, that was certainly in the very early days of DBAs. That was something that I remember concerned some clients of ours. In fact, they said, we've signed up our first DBA. I said, oh, yeah, good. Was it, you know, how did it go? We were so worried about it that we videoed the client care interview, so that the client could never deny that we'd actually had this conversation, which went along the lines. So if I phone up your opponent next week and they cave and they give you X, you're still going to give us Y, yeah? That sort of thing. That was their concern.
Well, I mean, look, as a client, piece of client care advice, it's not all entirely stupid, is it? I mean, there's a lot of
absolutely not. Absolutely not. I think they're very wise. But I mean, I think that the whole of this is I'm not so sure now that whether I don't get the impression that there's actually a pent-up demand from solicitors to enter into DBAs. I think it's been such a a cautious approach to that so far that I'm not actually sure that this is going to signal liftoff in any way, just from a practical level of whether that's the way solicitors are going to want to enter into agreements.
Yeah, look, I think that's true. I think that the DBAs have been there but not there for so many years now. Solicitors aren't very interested. Clients have had them explained to them 2 or 3 times, but then told, but it doesn't really work. And anyway, clients aren't particularly keen on losing a share of the spoils. There's a certain sort of solicitor who thinks that for a certain sort of case, this is tremendously exciting and attractive. But usually their clients smell a rat and run a mile from that sort of approach.
Yeah, exactly.
Do you think we can now expect precedents from the Law Society and the Bar Council? They've been very reluctant to commit themselves to writing so far.
I would have thought so, but I think they're going to be quite limited to the sort of situation we were talking about a little earlier, which is to say the straightforward DBA, which merely provides for a share of the spoils plus basic costs in the event of termination by the client. I don't think we're going to get a set of sophisticated precedents dealing with either consecutive or concurrent DBAs, which is a shame, because I think insofar as people want things, those are the things that are a great deal more useful than a completely conventional DBA, what's about to become a conventional DBA involving only a share of the spoils plus pay in the event of termination.
Well, still on DBAs, we do have this decision of the Court of Appeal and the Divisional Court, same people sitting in 2 different capacities, last Friday, on whether a litigation funding agreement is a DBA. And
it's, where's the headline? The answer is it isn't. No one really thought it was. I know the next topic we're going to deal with is these class actions, which are finally 5 years after they became lawful, finally about to start happening, or at least start being fought. And what's so interesting about them is they are worth so much money that it's worth taking almost any point. And this is a classic example of exactly that. I can't imagine that the truck companies really thought they had much prospect of successfully persuading a court that anyone who funds litigation is in fact entering into a DBA. But if it succeeded, it was marvelous in business terms for the truck company, so it was worth taking the point. And so they took the point, and they decided, unsurprisingly, it wasn't. It's more of the same badly worded regulations that we were talking about earlier. The three judges in Lexlaw sort of say, well, it's not our fault that we don't agree. At one point, they sort of say it's not our fault we don't agree with each other. It's because the regulations are so badly worded that we all need to say something different to each. We all need to set out our individual thought process. Again, it's those same bad regulations that mean this point was even slightly arguable.
Anyway, well, it's good that it's out of the way. I'm sure. I remember actually discussing the point with the Litigation Funders Association when when LASPO was going through and saying, look, there is this risk because the wording is not good. Why don't you have a word with the government and try and get them to make it clear? So they had a word with the government, but of course there was no response, and the wording went through as it did, and now it's been sorted. And I don't think they've been losing a lot of sleep over it over the intervening years, but it's one thing that one less worry for them. Put it that way.
Yeah, well, yeah, no, I'm sure they're relieved. Before we leave the topic, actually, can I just mention severance, because that gets talked about in Lex Law. It isn't how their case is eventually decided, but severance has always been a sort of a potential solution to these difficulties of the unenforceability of retainers. But it's a potential solution that hasn't worked, because in the costs wars, the court said with some enthusiasm, no, it doesn't work. But Newey in Lex Law doesn't decide on the grounds of severance and says we don't need to, but does speak as if severance would have actually been a pretty good solution if they weren't able to solve it any other way.
Yeah. I think it's a bit different though, because, or is it a bit different? I'm not sure if it would have been a solution to the cost wars on CFAs. We all argued it till the cows come home. I don't think anyone ever succeeded.
No, I don't think they did. No, I don't think any of us did.
But here we have a strongly purposive court, so that's
exactly the purpose of DBAs is apparently rather different to that of CFAs, which of course is partly a function of who's bringing the challenges.
Exactly. Right. Well, moving on then to Optin group litigation. What can you tell us about that? The decision isn't that recent, but it's still a reasonably recent decision. Andrew, what do you got to say about that?
Well, the answer is that the Optin group litigation is a new beast. It's very different to anything that we've ever been used to. And therefore, the cost problems it's going to throw up are going to be very different to anything we've ever become used to. This is about American-style class actions in which claims are brought up effectively on behalf of an entire class of people disadvantaged by unfair competition or something of that sort, people who've paid too much for a mobile phone, people who've paid too much for a truck, something of that sort. And they are going to proceed in a completely novel way in the Competition Appeal Tribunal, and they have to be funded, therefore, and regulated in a completely different way. Seems to me there are going to be two very big areas that are going to cause conflict and cause the need for cost lawyers to get involved. One is that there is an inevitable conflict between the position of the litigation funders, because these things have to be funded by litigation funders because they're not clients in the conventional way, between their interests and the interests of the class of injured people who are going to get the damages. So the divvying up is going to be a very difficult and an important question. The other area that's going to be very difficult is the question of what you do about costs managing these cases, because you haven't got clients doing anything about that cost managing. And the Competition Appeal Tribunal isn't particularly familiar with costs, budgeting, cost management, or anything of that sort. It's not something they've had to deal with. As I said a little while ago, these are hugely valuable claims, many, many millions. The truck claim is worth, the truck's claims are potentially worth billions. And therefore it's worth people throwing huge amounts of money at all of this. There is a great deal of scope for argument. The recent Supreme Court decision didn't really deal with the cost issues at all, because the appeal to the Court of Appeal and then the Supreme Court was only in relation to issues about the quantification of loss and whether that could in reality be done. But in truth, one of the arguments that is going to be advanced in many of these cases as to why this is a case that isn't suitable to be dealt with under this opt-out class action approach is going to be relate to the way that the costs and funding is structured.
Andy, you've given quite a lot of thought to this.
Well, only in outline, because we've been hanging on for this effectively for 5 years. Which is I think when the first Mastercard certification hearings took place, and it's just because we're interested, because it's one of those very rare occasions, as Andrew's already pointed out, where the costs are completely detached from clients. Rather in the way that individual instructions are completely attached from clients, because they are. Now that's okay. We just get used to that. That's what legislation is set up. That is the system. That's how it works. But one would have thought that the court ordinarily would want to give even more consideration to cost management than they would in a normal large case, because I think large traditional pieces of group litigation, even though the aggregate value of damages might exceed 10 million or so on and so forth, are still ripe for some form of cost management, because there's a realization that it's so easy for costs to get out of whack in those sorts of cases. So why not these? And I think Andrew's alighted on the problem that we face, which is in a way experience and appetite, which is the tribunals are not used to working that way. They've always had jurisdiction to deal with costs themselves, or palm it off to Supreme Court Costs Office. I don't know what the stats are as to how much they retain and how much they pass over, but nevertheless, when they do keep it, rather similar to the way some arbitrators approach costs, it's a much more high-level discussion, and it doesn't go into the sort of detail, anything like the sort of detail that it does within litigation, and there is no experience there of cost budgeting. So, in order to protect the interests of the potential competing interests of people that are even supposed to be on the same side, it would seem to me that these cases would lend themselves to some form of cost budgeting. But who would do it? I'm not sure. I don't know whether they would, whether the tribunal would bring in specialists as a specialist to do it. The courts sometimes do that, but then of course they've got a structure of having masters that can deal with cost budgeting if needs be, and occasional expertise brought in by way of assessors from the cost office. So I suppose there's potential for that. And I just think that we don't know as much about it because as how that might work out, because it was never really dealt with at first instance, and it wasn't the subject of any appeal. So therefore, although it struck me as being a bit odd that the defendants hadn't put in a cost estimate or cost budget, so there was no way for the court to assess whether the adverse cost provision in the litigation funding model was enough. I think they just had 10 million. Now that seemed to me to be very low indeed, but it is what it is. And of course, at that point, the prospective defendants had much bigger fish to fry. They were really betting the house on the damages quantification problems rather than these sort of side issues. They'd rather the whole thing went. So I do get the impression that perhaps unlike our discussion with DBAs, that there are a number of potential actions building up behind the door, waiting for this certification to take place. And that was certainly the impression I had. I was kindly invited by somebody to attend a virtual conference of the great and the good on collective and class actions a couple of months ago. And I got the distinct impression that they were waiting for that this was going to like the blue touch paper.
I don't want to spring this on you unfairly, Andrew, but I don't know if the regulations permit, or the rules rather, permit the tribunal to bring in a cost judge and assessor, but that would seem to be a practical solution which would help enormously on the quantification of budgets.
I imagine the rules, even if they don't expressly provide for it, they can make someone a deputy judge of the CAT or something, can't they?
Probably.
You know, there's usually a procedural way around these things. Yeah. It's the question of who's going to grasp, as Andy effectively said, where's the appetite? Who is going to be? These are such big, difficult cases to case manage, and who's going to grasp the nettle? It's the usual costs difficulty that cost is tail end Charlie. Everyone worries about everything else. Direction of travel without realizing that actually this very large scale litigation very often becomes about the costs and not a great deal else.
Yeah, absolutely. Yeah. An insight which you and I had some years ago and is now becoming more widespread. Put it that way.
Right.
There was a wonderful quote just before I retired from someone in the Court of Appeal saying, specialist cost counsel, brackets, and I believe there are such things, brackets. Anyway, I think, yeah, Andy, you're quite right. Watch this space for quite a lot more. There are some, we've had a quick look at the legal press. There's a collective action over mobile phone chips. There's a collective action against Facebook for data protection. There's an action against Vauxhall for emissions worth apparently up to 20,000 a head in the best cases, which is a bit better than I think it's 30 quid in the phone chip litigation. I can't remember what we're all going to get from Mastercard. It's something similar, I think, if it's successful. Which reminds me, I must remember to opt in, because if you're not resident in the UK,
you're already in, aren't you?
No, you have to opt in if you're resident abroad. So it's another special Brexit rule. Moving on then, just a quick mention of Heathfield International and Axiom Stone London, Andrew.
Right, another case in which the significance isn't so much what's actually decided as to what's sort of mentioned on the way to deciding it. This is a decision of His Honour Judge Simon Barker, sitting in Birmingham in the business and property courts, and he's faced with a useless party that's failing to comply with cost budgeting, and therefore, in principle, under CPR 3.13 and CPR 3.14, entitled to a budget that consists solely of the court fees. But he says, I think my discretion is in fact much wider than that. I don't think it is a binary choice. I think I would be entitled to say that the just outcome would be partial relief from sanction. That it is that actually I can say that certain phases we should get nothing, but for other phases it can be effectively a conditional order saying that if you do X and Y, put in a competent budget right now to cover trial and trial prep, I can allow a certain level of costs for that. He then turned around and says, but this particular litigant is so spectacularly useless, I'm not going to do it. So this is obiter, and so it isn't going to be binding on anybody. But I think it's going to be quite attractive to quite a lot of judges. Because I have to be truthful and say I think judges do find this quite uncomfortable. The thing of saying that it's an absolute binary choice between people either either, as it were, accepting people failing to obey the rules or imposing a very draconian penalty. And if they could take a middle way and penalise them a bit, but not totally, I think that's something that could well catch on.
Must be right, mustn't it? And I mean, the logic of the judgment on that is impeccable.
Yeah, absolutely. Just not
Yeah, no, I agree.
Anyway, not a great deal to say about that case. So let's move on to the final topic we were going to talk about, which is the year of lockdown. This is a sequel to a discussion we had with the senior cost judge just before Christmas in our last, it's the last thing, one of our recent cost chat between friends, in which he was describing what it had been like to be in the cost office and effectively running the cost office under these extremely difficult circumstances, and how they've innovated and dealt with the problem. But let's switch now to the view of the practitioner, both of you as practitioners in this respect. What would you say your year has been like, Andrew?
It's all worked a lot better than we would have expected. I think, and credit to in fact, to particularly to the cost judiciary, because they've coped well with the tech, and this is an area in which technology really matters. It's to their credit that they moved to Teams rather than Skype for Business, which is a good platform. I'm slightly troubled by the new platform called CVP, which is the court dedicated video platform. I've had one hearing on that, not in the cost office, but in a district registry, and that was not as satisfactory. It's not terrible. But it's not quite as good as Teams. But I think it's felt to be even more secure than Teams. And so I think that's the route the courts are now going down. I think what's so interesting, looking back on the last year, is if we'd had this conversation 2 or 3 weeks in, we would have been absolutely clear that this was a blip and normal service would resume very shortly. And I don't think for lots of hearings it's ever going to resume. I think lots of hearings are going to continue to be virtual and remote. Lots of interlocutory work can be done perfectly efficiently as a remote hearing. And I think a lot of people aren't going to therefore go back to interlocutory stuff happening in person at all.
What about you, Andy?
Yeah, I think that, well, just before we move on to me, I'd like to ask Andrew a question more about his sort of like general working arrangements, which is, you mentioned earlier how Jeremy would, popped into your office in Chambers one day and said, I'm having a bit of trouble with this, can you help me? And look what happened. I mean, how can that sort of thing, is that sort of communication between you in Chambers, is that still operating as it might have done before in terms of the water cooler chat, as the Americans call it?
No, it doesn't work nearly as well, Andy. You're absolutely right to say this. When we first started a year ago, we tried to use Teams, the chat function within Teams, as a means of creating a virtual version of this. Yeah. So people would say, "Oh, that's something to happen at court, and this and that, and what do you think?" And you know what it's like in organisations. There's a handful of marvellous people who actually did post and comment on other people's posts, but most of us just got on with the next thing, cursed the judge, and moved on to the next problem. And actually, it's quite difficult to create a virtual equivalent to chatting around the kettle. And yes, we've definitely lost something. And if people don't come back to Chambers, if you don't go back to the office, that's going to be problematic, because particularly for the juniors, they're not going to learn without people to talk to. I was talking to one of our junior tenants, and he has now been on his feet for a year, and he's done it in an actual court once. He's been in court sort of four times a week for a year, and it's been virtual almost every time. And he'd certainly come across some real difficulties, which actually he would have benefited from walking into a room with colleagues and talking it through with them, but he didn't feel he could phone up and do so. And we said, do just phone up, just pick up the phone and talk to someone. But it's tough. It's tough to do that.
Yeah, no, I can identify with that. And I think that probably what's helped us is having a team that has worked together for a number of years. We've been fortunate in terms of we haven't really had any personnel changes for about 3 years now. One retirement recently, that's about it. And to have to start to form those relationships from scratch, if we were to bring in somebody new, I think there would be enormous problems with it that we'd find it difficult to get over. But I think the fact that we already had to find ways to work together, because we seldom seem to get involved these days with, sort of one-person jobs, as it were. And that's been our way for a while. Translating that to the virtual environment has actually been quite effective. So we have used Teams quite extensively, and we have, if you like, small teams within Teams, as it were, who do have video conferencing on virtually a sort of a daily basis. And we're small enough with sort of 14 or 15 people to have a couple of structured Teams calls a week, at least one of which where we try and say we're not allowed to talk about work. So I mean, we do. I actually do get tapped up by colleagues to say, can I just run something past you using the chat function? But I think because we've got a form of hierarchical structure, not as flat as, flattish, but not as flat as a barrister's chambers, means that there's a chain of command that lends itself to that sort of communication anyway.
Yeah.
Which there isn't when it's just peer-to-peer necessarily. But I mean, I completely agree with you, and this is sort of, areas we covered with Andrew Gordon-Saker, that the cost courts in particular have coped surprisingly well. And I can't see it returning to what it was. I think the split between interim hearings and substantive hearings is probably right. There'll be more of a return to face-to-face in full assessments than there is in interim hearings, directions, appointments, relief from sanctions hearings, and so on and so forth. And maybe I hazard to guess we don't do many, but it would make, given that the costs of doing it, the cost penalties and getting it wrong are quite extensive. If you wanted a hearing following on from a provisional assessment, a lot cheaper to do that on a remote basis, I would have thought as well, and that might encourage a little bit more of that when the time comes. Biggest change, well, the forcing down the line of the adoption of Excel for assessments has been a big move, and that's very welcome. That's helped. The final frontier seems to me to be document management. I think we've got to become all as smart with, Acrobat DC Pro or what have you as we had to be with Word, back in the day when that was the that was the application that meant that people could communicate electronically. I actually, on balance, despite the fact that it's a massive amount of front loading, I actually prefer the bundle being before the court, well prepared, bookmarked before a hearing, because it's the only way you could do it electronically, as an alternative to leafing through dusty lever arch files and breaking your fingernails on those lever arches that never work. That I think should stay. I'm not sure whether, apart from the social aspect of it, I'm not sure why people would necessarily be gagging to get back into court.
Yeah, no, that's really interesting, Andy. I mean, what strikes me is, and what you said about the close-knit team is very important, because what strikes me particularly with remote negotiations, remote roundtable meetings, remote mediations, is if you're negotiating with people you know already, they work very well. If it's new people you don't know, you don't have an existing relationship with them, then building a relationship remotely is very tough. And I think it's the same with judges. If you know the judge, then again it's actually quite helpful, and so therefore the Costs Office is a good place to be practicing. The Queen's Bench Division is a harder place to be practicing, because you've got it's dealing with the tech is difficult. There's endless new pitfalls that can happen with the tech, and as you were saying, with document management, and indeed we demonstrated one a little bit earlier. We set this up for 4 o'clock on a March afternoon. The sun came shining through for the first time in March, straight into my eyes, into my virtual background when we were doing the first 20 minutes of this chat, there was a problem that over the winter has not happened to me once before previously. That the sun, there's actually been strong enough sun to that my visuals are being mucked around, because there's a whole load of technological stuff that we have got to be adept at, so that you don't even notice it, and we can get on with the advocacy.
Yeah.
The other thing that strikes me is advocacy has to change, and more for the barristers than for cost lawyers. But the sort of traditional barristers' advocacy can be very unacceptable if you've got someone who's a bit hectoring and a bit pompous, and that person is now not at the other side of the court, but on the judge's desk. That's pretty unacceptable, isn't it? And lots of it. So the approach to advocacy has to change, and that's been really interesting.
Yeah. How have you found it with getting yourself tugged from behind by instructing solicitors? Do you work that with a sort of WhatsApp group going along the side of?
Yeah, another. Or Teams messaging, another platform with a chat function open in it. But of course, because that's easy for the solicitor, they can be sending comments all the time. Whereas when they actually had to write something down and pass it forward to you, an editing function meant they'd only actually pass the message if it really, really needed to get through. The danger is that you're watching a constant flow of comments, only some of which are actually useful, but it's distracting you from what your opponent or the judges say.
Exactly. There's only so
message
much,
for solicitors there, I think.
Only so many sort of, I can't believe he's swallowing this sort of comments that you can that are particularly helpful.
Absolutely. Well, it's when you're getting emojis in, that's when you've got to be a bit trouble. When you're getting you've got champagne bottle emojis coming into the chat. You need to bring a stop to that pretty promptly.
Yeah, exactly. And how about there was one thing I noticed. Deborah, who was helping us prepare for this, helpfully sent us that Baker and McKenzie report, and they suggested there might be some sort of hybrid arrangements would become quite popular, where you wouldn't need the advocates might be in court and maybe one other people, but other people that were just going to be there to be taking notes or sitting in the background might actually attend virtually. I wonder whether that might catch on. I'm not sure myself.
Yeah, I'm not sure. I mean, I think one of the interesting issues is going to be how many people are needed for a court hearing. If you were talking about the document manipulation, I'm not sure one doesn't need a sort of courtroom assistant to be manipulating the documents, manipulating the virtual bundle, and making sure that the virtual documents are in the right place.
Yes.
And both on big digital assessments and indeed when coming to assess the cost of big trials.
Yeah, I mean, I think there's a limit to. I mean, I think there's a threshold that people should be able to get over themselves. I mean, I'm still a bit staggered that people giving down the street press conferences can't click the slide on to the next one. And there must be lots of court equivalents of those. But I definitely found that when I did an assessment recently. I felt that I would have felt floundering if I hadn't had somebody helping me from my firm whose job was purely to make sure they were keeping track of decisions and results and feeding them into the spreadsheet, so that I didn't have to do all that at the same time. And yet probably wouldn't have done that if I'd have been in person, probably, or certainly not in the old days. If we're talking about putting notes on notes on bills and adding it up later, there again, 5 minutes after the end of the hearing, we were able to turn around to the client and say, this is how it's going. So it's actually better, as well as being, it's more costly at one end, but slightly cheaper at the other.
Excellent.
Yeah, no, I think that's I think that definitely is a very real change.
The Baker and McKenzie report also suggested that people weren't keen on mediation online. I suspect for the reasons that Andrew's just given, the sort of the water cooler effect. Although interestingly, not many people who they surveyed had participated in an online mediation, and those who had were relatively satisfied with the way it had gone. I found that an interesting conflict, because certainly intuitively, I would have thought exactly what you just said. It would be difficult to form those relationships that enable one to get across the difficult points of a mediation.
I've done two. Have you done mediations in virtually, Andrew?
Yeah. And the more structured it is, the better it works remotely. So a structured mediation with breakout rooms and moving people from room to room, of course, can work quite well. A less structured environment can be difficult remotely.
Yes, yeah, I can understand that. I think ours technologically worked quite well. The breakout room idea, the mediator moving between two rooms. I've always thought one of the attractions, perhaps it says more about my personality than others, but one of the attractions of mediation is that you cut down on the amount of face time you have with your opponent. you spend most of the time in your own room, and not so much on open sessions. But certainly I found that side of things worked well. Maybe I think there's some force in the idea that when you're all trapped in the same four physical walls together, there's a pressure on getting something done. You wear yourself down, and when all you need to do is click and you're out of there, and you're controlling your own environment, you can
absolutely
comfortable, and there can be drift.
Yeah, you come to Chambers to make a deal. You come to the meeting to make a deal, and if you don't physically come to the deal, then there isn't the same incentive to close, to actually reach a compromise, reach an agreement.
Yeah,
That's very interesting.
I mean, they work better. Sorry.
No. I was just going to wrap up, really. So, what were you going to say?
What I was going to say is I found that as with court hearings, they worked a lot better than expected. It doesn't mean, I think there are advantages to doing it in person, but I suspect that a lot of ADR of all sorts is going to remain remote. I think we're not going to go back to always meeting in person to do this.
Well, that'll be good for the environment. I must say I find it quite reassuring that things have gone really much better than I would have expected during this period of lockdown, and that seems to be certainly in the field of costs, the universal view. I think perhaps in some other courts matters have struggled a bit more, but the costs office has done extraordinarily well, and particularly given that they are very, very document heavy, in potentially at least, as a court, and they seem to have coped very well with it, which is very nice to hear. And I'm sure Andrew Gordon-Sake will be watching this with avid interest, and will be pleased to know that as a participant, as opposed to a person sitting behind the desk, you would agree with that. Well, thank you again very much. I hope this chat has been interesting to all of those who are viewing. The next one we haven't yet scheduled, but we look forward to it. I look forward to it. And in the meantime, keep safe, everyone.
Thank you very much. Thanks, Jeremy. Thanks, Andrew. Thanks for sparing the
Thanks,
time.
Jeremy. Thank you, Andy. Thank you all.